to our CIPD Northern Ireland Employment Law update. This is the third event in our People Hub series, and we are delighted that so many of you have taken the time to join us today. A bit of housekeeping. Obviously, I'm chair of CIPD, as most of you will know. I have Rob in the background. Well, he's not quite in the background, but he's running everything to do with technology, slide decks, and the chat function. So thank you, Rob. Whilst we would really appreciate you having your cameras turned on, as it does make it more engaging, particularly for our speakers, do keep yourselves on mute to prevent any background noise. And if you do have any questions, you can obviously use the chat function. This session is being recorded and we will share this along with the slides afterwards. So in terms of what we have lined up for you today, we've got our Pinsent Masons with us. Employment law updates are always one of our more popular events, and so I'm really pleased to have Paul Gillen, Ruby Rice and Craig Patterson, all from Pinsent Masons, who I know will provide an excellent and most informative session. Paul is a partner in the employment law team in Pinsent Masons and was past chair of the CIPD in Northern Ireland. He is a Chartered Fellow of CIPD, Fellow of IOD and a visiting Professor to the School of Law at Ulster University. Ruby Rice is a solicitor with Pinsent Masons and Craig Patterson is a Senior Associate in the employment team at Pinsent Masons and brings a wealth of experience in contentious and non-contentious employment law. I'm not going to say any more other than I hope you do enjoy the session. We will have an opportunity, obviously, for more interaction towards the end, and I'll hand you over to Paul, Ruby and Craig.
Thanks, Beth. As Beth says, we're going to cover a number of areas today. My name is Paul Gillen, partner in the team, and pleased to be joined by my colleague Craig and Ruby, who both sit in the employment team as well. And also we're assisted by Rob. So when you hear us asking for next slide, Rob's going to do the needful on that. So if you have any questions, then certainly put them into the chat and we'll try and get to those at the end. If you have anything more specific, then you'll have my contact details anyway if you need to ask anything else or you need further details on what we're going to cover. Rob, next slide. So the three areas to cover today, I'm going to spend about 20-25 minutes just looking at a couple of the key cases over the past 6 months to 12 months, just so you get a flavour of anything that you may need to do within your own organisations because of the developments in the case law. We're then going to go into tomorrow's world of work and look at a few areas, including the menopause, including greening HR, so some of the ESG stuff for HR to be concerned about, and then mental health issues within HR, and then we're going to finish with a bit of a horizon scanning where we'll set out what you should be looking for in the next 6 to 12 months, so anything that's on the horizon that you need to be aware of. Rob, next slide, please. So in terms of the case law updates, I've got 6 or 7 key cases that have happened over the past year that you need to be aware of, and then I've got a couple of need to knows or nice to knows for those people who are involved in some other specific areas, which I'll cover at the end. Apologies about that, through the case law stuff, because you will find that I'm going to have to refer to notes as we go through, because there's a lot of facts in this, but also some of the decisions and what was actually said by the tribunals or the court. Just so you have the details of verbatim of the decisions that have been taken. So the first one, Rob, next slide please, is a gender critical belief case, and you probably have heard about this from in the news or some of the HR updates, and this was the case of Forstater and CGD Europe, and this was a case of Miss Forstater who had lost a contract because of philosophical belief. So Ms. Forstater, who was a contractor, expressed beliefs on her personal Twitter account that biological sex is real immutable, and not to be conflated with gender identity. And that's one of the key things coming from this case, that there should be no conflation, even when you're collecting your data within the workplace on gender and gender identity. An investigation followed, which resulted in the non-renewal of Ms. Versteter's contract, and she claimed direct discrimination on the grounds of philosophical belief. So there was a preliminary hearing at the tribunal to see whether what she'd been putting out on Twitter was actually a philosophical belief, or whether it was an opinion or whatever. And if it was a philosophical belief, then whether it was to be protected under the Equality Act. So the ET focused on a test that came from a case called Nicholson and Granger. And this case set out 5 tests that a belief had to have to be worthy of protection. And one of those tests was that the belief must be worthy of respect in a democratic society, not to be incompatible with human dignity, and not to conflict with the fundamental rights of others. And on that basis, the tribunal found that Ms. Versteter's absolutist views, which is what they called them, were incompatible with the Granger test, and therefore it wasn't a philosophical belief and wasn't to be protected. Now, Ms. Versteter appealed to the Employment Appeal Tribunal, and that decided that the Equality Act, in terms of philosophical belief, should be read in conjunction with the European Convention on Human Rights, and in particular, Article 9, which is the freedom of thought, and Article 10, which is freedom of expression. But you should also bear in mind that Article 17 under the convention is the protection of abusive rights of others. So really what that's saying is you can have your own views, but they shouldn't abuse the rights that other people have as well. Now, what the EAT found was that the European Convention on Human Rights excluded from protection those beliefs that destroy the rights and freedoms of others. And the examples given was Nazism and totalitarianism. So absolutist views, in essence. And what the EAT said was that Ms. Versteter's beliefs, whilst offensive to some, and notwithstanding its potential to result in harassment of trans people in some circumstances, did not seek to destroy the rights of trans persons, and therefore they found that it wasn't a high test to pass that she would have a philosophical belief. So what came from that as key takeaways from the EAT judgment? The first one is that a belief need not reach a high level to be protected, and only those beliefs that would cut across the rights of others, such as Nazism and totalitarianism, would feel the test of being worthy of respect in a democratic society. So it's quite a low bar now to say you have a philosophical belief. And also they said that because gender critical beliefs are widely shared in society, they don't seek to destroy the rights of trans persons. But what they did say was that all they were saying was that this was a philosophical belief, and they didn't say that those with gender critical beliefs could misgender trans persons with impunity. So there were other cases around the same time where people were not calling trans people by the correct pronouns, and they shouldn't be allowed to get away with that, basically, because that would impinge on the rights of others. So what you need to do and remember from this case is that a philosophical belief will be anything that people do have that's worthy of respect within society. And even if it does impact on someone else's rights, it doesn't mean that their belief isn't worthy of protection as well. So what you have to do is be quite clear in your policy and procedure how things will be dealt with if it comes up as harassment. Because although Ms. Versteter and some of the other cases said that, I don't believe that I should call somebody who was born male, they choose now to be called by Miss, that I should have to do that. And your policy has to be clear that that is what happens, because if you do then dismiss or you take action against somebody, then it's on the basis of that and not because of their belief. So it's a really important decision moving forward. Rob, next slide. The second case is one on reasonable adjustments, which again is another important one to bear in mind, because this comes up time and time again where people are put into temporary roles. C was a science teacher who suffered mental illness, and this was constituted a disability. And after some time off, she returned to work, but was in a lower level supervisor position. This would normally attract a lower salary than a teacher, but for a period of 3 months of a probationary period into the new role, plus a further time because there was a grievance and appeal going on as well, she was paid still at the teacher rate. But at the end of this, she did accept the new role at the lower rate, but then went on to claim disability discrimination. And she argued that it would have been a reasonable adjustment for her to continue on the higher pay rate into the future and not just for that limited period. And the tribunal rejected her claim, and it accepted that it was reasonable to expect continuance of the higher rate of pay during the probation and the grievance, but not into the future. And it looked at a couple of other cases, including the Court of Appeal case of O'Hanlon and commissioners for HMRC. And in that case, the Court of Appeal held that although wage continuation is not legally ruled out, it would be a rare case where it would be found to be a reasonable adjustment. And I suppose there's a lot of employers that would breathe a sigh of relief on that. But it's not as straightforward, because what you need to do is to consider the facts around this. So if you do have someone in a job that you're putting them into to try and get them back into the workplace as a reasonable adjustment, you have to look at how reasonable it would be to continue that person in that role on that level of pay. And if it's just because of cost, then the tribunal would frown upon that. But if there are other things, such as putting someone into a lower level role, getting a higher rate of pay, just how much that would impact on things like if you're, say, a charity and how much it would cost to run that, or if it's from the public purse. But also that you have to bear in mind other issues within the workplace. So if, say, for instance, this teacher was put into that supervisor role but paid at a higher rate, then a male supervisor could then claim that there's an equal pay issue here because she is on a higher rate. So there's all of these things to consider, but thankfully what the courts have now confirmed is it's not automatic that someone would continue on that higher rate of pay.
I think, Paul, the other important point that came out of that case as well, and what differentiated it from the G4S case. So the G4S case a few years ago, it was held that maintaining the higher rate of pay was a reasonable adjustment. But what was differentiating here was in G4S, the employee was under the impression that increase in pay would be permanent. So it's just a reminder that if for whatever reason you're moving someone into a role on a temporary basis and ring fencing their pay to sort of ease them into a lower rate of pay, that communication is really clear, that any higher pay is a temporary measure, and there's the consistency in that messaging as well to avoid any suggestion that it was a permanent change.
And some of the others that have held the reasonable adjustments is that you would have a time limited, as Craig said, to make clear that would be a time limited increase or continued payment at the same rate. But to have a taper system as well, where you can taper off. So say the person is on the full pay for 3 months and then taper down to halfway between the old rate and the new rate, and then down to the new rate. So there's all of these things, and just to make clear with the employee what is actually happening. So next slide. This is in relation to Section 44 and 100 of the Employment Rights Act, and also the same in the Employment Rights Order in Northern Ireland under Article 68 and 132. And this is where an employee may refuse to return to a place of work or to take appropriate steps to protect themselves or others if they can establish that there is a danger which is both serious and imminent, one which they could not reasonably be expected to avert, and their belief in this regard is both genuine and reasonable. And there's a couple of protections within the Employment Rights Order on this basis. And the first is that the employees are protected from detriment. And this is, for example, not getting paid for not attending work. And the second is for protection against dismissal. And under the Employment Rights Order, it would be automatically unfair to dismiss someone on this ground. So it is actually quite important when you consider what's happening on people returning to the workplace post-COVID. And traditionally, employment tribunals have given the word danger a broad interpretation, and therefore it's quite likely that COVID-19 crosses that hurdle, and that would amount to danger, and that would be serious and imminent because of the nature of COVID. And the issue on reasonable belief is that it all turns on what the employee tells the employer. So that there is that belief of whether the danger as seen is a reasonable belief. It can also be considered to be a protected disclosure. So if an employee is saying there are issues with your risk assessment or issues with your PPE, then that can amount to whistleblowing as well. So to bear that in mind. Now, there's a couple of cases just to cover with you on the next slide of how this has been applied in the case of COVID. And the first one is the case of Gibson. And Gibson, Mr. Gibson worked as a chef in a restaurant that was owned by Lothian Leisure. And the restaurant closed temporarily in March 2020, as a lot of other businesses, due to the lockdown. And Mr. Gibson was furloughed. But when the restaurant was opening up, they asked Mr. Gibson to come in and do some preparatory work. And he said he was concerned about catching COVID because his father was clinically vulnerable. He raised concerns about the lack of PPE, and also that there was no risk assessments and it wasn't a COVID secure workplace to go back into. And his employer simply was negative about this and said, shut up and get on with it. And without prior discussion following that, the employer dismissed Mr. Gibson summarily by text message on the 30th of May 2020. And it said that Lothian Leisure was changing the format of the business and would be running it with a smaller team after lockdown. So it went to tribunal, and the tribunal held that he had been unfairly dismissed under Section 100 of the Employment Rights Act because he had taken steps to protect his father, and that he had a reasonable belief that there was serious and imminent danger to his father because of COVID. But they also said that because of the nature of the text, it was also a possible redundancy situation, and because they didn't have any records or anything to show that there was selection of people in having a smaller team, they said that those were steps which was unfair selection because of raising the issue as well, and that it was automatically unfair dismissal. They also found, because the company was arguing that it was a smaller team and that wasn't reason for the dismissal, they found that before raising the concerns, he had been a successful and valued member of staff, and therefore, it was on the basis that he brought these issues of the COVID-19 secure workplace. But in that case, they did dismiss the whistleblowing provisions because it was in relation to the health of his father and didn't have a wider public interest. Now you can cross-refer that to the case of Rogers. And Mr. Rogers also claimed that there was imminent danger of coming back to the workplace because of COVID. And he had a son that suffered from sickle cell anemia, who was clinically vulnerable. But when they looked at that, the employer had done risk assessments, and they found that there were only 5 people at any one time in the warehouse, and that was half the size of a football pitch, and therefore there wasn't imminent danger. But they also found that Mr. Rogers himself had been working in a pub part-time as well, and there was no issues with that, and therefore they found that he wasn't dismissed on the basis of the protections, the health and safety protections under those articles or sections, and therefore that he had been dismissed fairly. So I suppose the takeaway from this is to ensure, not only in terms of COVID, but you do keep your risk assessments up to date, and that as far as possible you identify risks and show how you want to remove or to mitigate those risks for employees. On to the next case then. And this is one that is really important in terms of discrimination. In all discrimination cases that we defend on behalf of our clients, we always put in what's called a statutory defence. And this is a defence where an employer can say, I put into place all steps that were reasonable to prevent discrimination or harassment from taking place. And that's by having your policies and procedures in place, by having your training, and by actually addressing when harassment or discrimination raises its head within the workplace. So in this case of Ali and Galen, another EAT case, Galen, who was of Indian origin, complained to a manager that another employee, Mr. Pearson, had made racist remarks to him on a regular basis throughout employment. The manager took no action apart from telling Mr. Galen to report the matter to HR. And some of the racist remarks had been overheard by 2 other employees, including another manager, and neither had escalated the matter to HR. So when Galen went on to bring a case of harassment to the tribunal, the employer sought to rely on that statutory defence, pointing to the fact that it had an equal opportunities policy, an anti-bullying and harassment policy, and it had trained staff, including Mr. Pearson, and therefore they said that they shouldn't be vicariously liable for the harassment. However, when the tribunal heard all the evidence, they found that the training had been 20 months before the harassment took place, and that although there was a slide on harassment in the training, employees did not fully understand what that meant, and also there was nothing to say what managers should do if managers or other employees, what they should do if they overheard unacceptable remarks, i.e. report it to the HR and kick the process off. So it's important on that slide that you look at what the tribunal have said about this, because it can impact on whether you'd be able to use that defence in future. And they said brief and superficial training is unlikely to have a substantial effect in preventing harassment. So what you should have is training that is effective and long-lasting, but also that you have training that's repeated on a regular basis. The fact that employees have attended anti-harassment training but have not understood it or have chosen to ignore it played a big part in this case as well. And what they said is that an employer should have practices in place where if there is harassment, that it's brought to the attention of the employer, and that steps are taken to stop that. And the final one was that they were quite scathing that a manager had been aware, but despite being aware of that, wasn't escalated and wasn't stopped. And on that basis then, they said that the company could not rely on that statutory defence. So the takeaways from that case are, it's not sufficient just to have training as a box check exercise, and that you should ensure that employees understand what that means, but also have updates. So don't just train people when they come in after induction on anti-bullying and harassment, but have that as an ongoing training session throughout employment. And also to empower employees and managers to take steps to deal with harassment if they hear about it. And one of the things that you have in your policies on that basis is that if employees do come across harassment or discrimination of another employee and they don't raise that to the employer, that they themselves could be liable for that harassment and subject to disciplinary action, including dismissal. Okay, so next case. Oh no, more about holidays. I'm sure everybody would sigh a big sigh here, and that it's not all over yet for holidays and holiday pay. But this is quite a discrete case. So in terms of Pimlico plumbers, which you've probably heard about over the past year and a half, this was another part of the case where an employee had already been found to be a worker within the meaning of the Employment Rights Act and also under the Working Time Regulations. And the Working Time Regulations does allow employers to say at the end of a holiday year, any holidays that are untaken are lost, and that's absolutely fine. But in this case, what Smith was doing was he had taken unpaid leave throughout the year. So any time that he had taken leave, it was unpaid, and he had claimed for that to be paid. But he had then also said that his claim included a claim for payment for accrued holidays which he hadn't taken. So he had leave that he'd taken which was unpaid, and he also had other accrued holiday which he hadn't taken. And there was two things in it. The Court of Appeal was had to decide whether that was an argument in his original claim, and they found that that wasn't. But they did go on to say that if a worker takes unpaid leave when the employer disputes the right and refuses to pay, that the worker is not exercising the right. And this also applies to when an employee isn't allowed to take holidays. So if they're not deemed to be an employee or a worker, and therefore they don't take their leave, unpaid or otherwise, then they can carry that all over to the end of their employment and get paid for that. So I suppose that the takeaway from that is also to understand the rights of each individual within your workplace, and also that you're encouraging people to take their holidays. So don't just leave it to the last fortnight before the end of the holiday year and then let employees lose their time, but you should encourage employees to take holiday throughout the year. The next couple of cases are in relation to slightly the same as this Smith case, but it's in relation to worker status. So this case of Somerville and the Nursing and Midwifery Council, a Court of Appeal case from 2022. In this one, the council appealed against the decision of the EAT that the individual was a worker. So the individual had been appointed as a member and chair of a fitness to practice committee, and that was under a services contract that lasted four years. And under the contracts, the individual could provide, the council could provide the individual with a list of hearing dates and provide reasonable notice to attend. But that the individual was allowed to say no, they didn't want to attend those hearings. So on that basis, the council said that the person was not a worker. But the Employment Tribunal held that there was an overarching contract between the council and the individual, and that this did not amount to a contract of employment or a worker contract. But they said that each time that the individual was asked to sit on a committee and they said yes, that did form another contract underneath the overarching contract, which meant that that person had to undertake the work on a personal basis. Now, what the council argued was that the individual didn't tick all of the boxes for the tests of employment. And if you remember those, that includes what's called the irreducible minima of three areas. The first is control. The second is mutuality of obligation, where someone, if they're, the company has to offer them work and the person has to do the work that's offered. And the third is personal service. So they're not allowed to pass the work on to someone else, they have to do it themselves. So those are the three tests for employment. But what the EAT said was that irreducible minima is not, you don't need all of that to tick the box for worker. And the only thing you need is a prerequisite for carrying out the services personally. And because Somerville had to carry out those services personally, they were a worker. And on that basis, we're entitled to worker rights, including national minimum wage and also holidays and rights under the working time regulations. So the key takeaway from that is to understand who you have in the organisation, and if there's an individual and it's not clear whether they're a worker or not, that you look at, revisit that and see whether they have worker rights. And that ties in with the next case of Uber, and I'm sure everyone's fed up hearing about the Uber cases as they've gone through, but there was another one through the support in 2021, And here, private hire vehicle drivers who provided their services through the Uber app fell within the definition of worker, and that was under the it's called Lim B in the Employment Rights Northern Ireland Order and the Employment Rights Act. So this is where someone who's working under a contract, but they provide services personally. So they were working under contracts with Uber as per the Employment Tribunal's findings, but that they weren't when they were off the app. So it was when they logged into the app that they were found to be workers. And even though there was a certain amount of control that Uber had, the control of the drivers was that they didn't have to log on to the app if they didn't want to. But the court was quite clear that once they did log on to the app, that they were workers. And in terms of working time, they said by logging onto the app, the drivers came within the definition of worker, and that was through the contract with Uber. And the tribunal was entitled, and this is all other tribunals as well, to find that working time within the meaning of the regulations was not limited to time spent driving passengers, but as soon as they logged onto the app. So it's one of those ones that in the gig economy, there are certain challenges. And if you do engage people on that type of contract where you're saying they're actually providing you with contractor services, you may need to consider that, because the court is now on a trajectory where they're trying to protect the vulnerable worker rights as well. So if you do have any issues on that type of person that you engage, then you should revisit that. Now, the final case I'm going to cover is one where we always think about people who have protected characteristics, and there was that joke of whether somebody who is in their somebody who's a white male who's 40 does have no protections because they don't fit into any of the protected characteristics. This is one that does show that you have to be very careful, and especially when you're looking at things like positive action. So B&J were creative directors for an advertising agency, and they were heterosexual, white, middle-aged men. So again, those people that you'd say don't really fall within the protected characteristics. There was a presentation carried out in May 2018 where there had been a new HR person who'd been appointed, and they were looking at the reputation of the agency. And in the presentation, they said that one thing we all agree on is that the reputation JWR once earned as being full of white, British, privileged straight men has to be obliterated. And the two middle-aged men went and complained and said that they felt that they were trying to hound out straight people from the creative department. There was a redundancy exercise that was carried out, and lo and behold, JMB were selected for redundancy. But when they looked at it, there was no contemporaneous notes of their performance. There had been selection notes kept, but they were only kept on those two people, not on any of the other employees. And therefore, they found that the decision had been taken. In fact, this was the evidence of the company. The decision had been taken just after they'd raised this issue of them being obliterated because they were privileged straight men. And on that basis, they found that the claims for sex discrimination were upheld. So the senior executives who complained had been victimised under the Equality Act when they were pre-selected for redundancy because they complained about the potential impact of their jobs because of the positive action approach. So the company was trying to change its reputation, and on that basis they were selected. And it was on the grounds of they complained, but also unlawful sex discrimination and harassment related to sex. So takeaways from this is to ensure that if you are looking at a change in reputation, any positive action, that you should be careful that it doesn't impinge on the rights of others as well. Also through a redundancy, to make sure you keep and retain contemporaneous notes, and to show how other employees have been selected as well. Now, I've got one final slide, and I'm not going to go through this in detail because there are they're quite specific cases, so it mightn't be of interest to everybody. The first one is Fenton, and this is a case where if someone resigns, and after they resign, you place them on garden leave, or you pay them in lieu if that's within their contracts, then they can't claim that you've dismissed them because their resignation has already taken effect. The second one is an expectation of privacy. So if you have anyone that is allowed to use work emails for private emails as well, you should ensure that you inform your employees that there's no expectation of privacy, and that those email accounts belong to the company. So ensure that that's set out in your use of IT policy as well. The case of Coastal, if you have a process of collective bargaining, then this is a case where you shouldn't overstep the mark from the agreement that you have with the union. And if you are going through collective bargaining, that you shouldn't go outside that and make individual offers to employees, because this will undermine the collective bargaining approach. So if you have a unionized environment and you go through collective bargaining, make sure you read this case, because it does set out what you should do in terms of communication with your employees individually as well. And also quite a technical case in Holcombe Laboratories, a Northern Ireland Court of Appeal case. If you have restrictive covenants that you want to enforce in the workplace, have a read at this decision, because it does go through what you should consider when you're drafting and seeking to enforce the restrictions as well. But as I say, those cases are a bit more specific, so I didn't want to cover those in any detail, but you can get them online if you wish. I'm now going to pass over to Ruby, who is going to start tomorrow's World of Work. And I think Ruby is starting with the greening HR and climate change.
Yes, it is indeed. So hi everyone, hope you're all keeping well. As Paul says, I'm going to cover two topics today in relation to the tomorrow's World of Work. The first is greening HR, and the second is then on menopause. So two quite nice topics, I like to think. So first things first, what is greening HR? For the benefit of you who don't already know, greening HR can be defined as a set of policies, practices and systems that stimulate the green behaviour of a company and its employees in order to create an environmentally sensitive, resource efficient and socially responsible organisation. Next wee slide there, please, Rob. Thank you. So greening HR and climate change is a hugely topical area at present. I'm sure most people have come across it in one shape or form or the other. In terms of some brief statistics in relation to climate change, then humans are likely to have caused an average global temperature increase of 1 degree Celsius. The temperature is likely to reach a rise of 1.5 degrees Celsius between 2030 and 2052 if we continue in the same trajectory that we're currently on. We're seeing more and more extreme weather conditions and events across the globe. The ice caps are melting and the sea levels are rising. There's forest fires happening in warmer climates. Some of you may have seen the ones that happened in LA over the last couple of years. Anyone who's fans of the Kardashians will have seen it featured quite heavily where all the celebrities live. There are issues for biodiversity, crop failures and deforestation, supply chain interruptions, and mass migrations are all becoming more frequent as a result of climate change. It's pretty universally accepted that the risks to the world are much higher if we see a global temperature rise above 1.5 degrees Celsius. Some of you may have come across or heard about the Paris Agreement, which is a legally binding international treaty on climate change, which is signed by pretty much every government in the world to include the United Kingdom. And this treaty or this agreement has set itself the aim of keeping the temperature level rise below 2 degrees Celsius. So proactive action needs to be taken by each country in order to ensure that they meet this objective. Just next slide, Rob, please. Thank you. So why are climate change issues relevant to HR teams? Don't you already have enough to do? As I hear you say, I remember in the background there. Well, there are a number of reasons you'll want to put this on your agenda or to-do list. First and foremost, from a moral viewpoint or morally speaking, it is the right thing to do. Climate change is an issue for all of us as human beings, and it impacts the entire globe. What happens here, for instance, in the UK will have a knock-on impact in other countries across the world. But there's also clear business reasons to act now. These come from a number of areas, but generally as humans and as businesses, it's accepted that we have a duty to leave the world in as best a place possible for future generations. I don't know whether anyone had seen the recent David Attenborough. Well, it's maybe about a year or two old now, which basically sort of showed what we can expect to happen in future years if we continue on the same trajectory that we're currently on in relation to climate change and greenhouse gases. It's quite harrowing viewing, but eye-opening all the same. So taking it back to the HR, in terms of some of the business reasons, then why does it matter to you, or why are HR members required in relation to this initiative? Firstly, employee motivation and employee satisfaction is a big reason. It can assist in instilling a sense of purpose within your workforce. There are a lot of government and policy mandates that have come out over the recent years, and a shift in the governmental focus to green jobs, as well as areas around mandatory and voluntary reporting being bestowed upon businesses. There's also a lot of pressure to start voluntary reporting from investors, clients, employees, and customers. They want to know what businesses are doing in relation to green HR and climate change initiatives. It's also increasingly becoming a C-suite issue. So C-suite being your CEOs, CFOs, etc. They're coming under increasing pressure from investors, and the requirement to focus on sustainability and climate change is greater than ever. And as a result, then HR individuals are likely to find themselves being asked to look at environmental issues. Other reasons, then, potential clients will take account of social value when deciding whether to award contracts with certain businesses. Obviously, business performance is something that does loop in with the HR side of things. Both public and private contracts will look at green initiatives when companies go out to tender and things like that. And then finally, from a sort of skills, recruitment, and changing demographics viewpoint, Green HR assists in attracting the new generation of what I would call climate conscious workers, as well as assisting in retaining them. There's definitely been, and I've seen it firsthand, a shift in generational focus to greener initiatives over the last few years. You can see even from social media outlets and pop-up stalls and things around the areas of responsible fashion, with new materials or new garments being made out of recycled materials, reusing things like that. It's definitely a major interest of the younger generation now. So to sort of evolve with the times and keep in line with these sort of traits, it keeps you relevant and attractive to potential candidates. They want to work for businesses that are doing good ultimately. And just on next there, thank you. So, apologies. As you know only too well, the role of HR is ever changing. It's constantly evolving to keep up with the times as new issues present themselves all the time. So when it comes to green HR, what is HR's role in all of this, or what can they do? So first of all, HR's responsibility for embedding sustainability in employers' ethos and culture is a key consideration. Climate consideration should be at the forefront of all business decisions and actions, and HR will have a major role to play in relation to that. HR is the conduit for change, and probably best placed to influence and direct any company culture or any shift that needs to come about, within company culture. They're probably one of the more influential teams within a business, as they work with everyone and link in with everyone at all levels of the business. So they're well placed to assist with this. Query whether a similar approach is required for green HR as is required for D&I, i.e. whether it's something that needs to be, you need to be looking at quicker wins, things that can be done in the shorter term, or whether it's a more long-term thing that you need to look at. I suppose my view on that is it's a bit of both. I've seen, clients, and I've seen certainly even in Pinsent's here as well, there are short-term initiatives that you can put in place that increase the visibility and awareness of green initiatives, things like recycling bins, reusable cups, printing double-sided or reducing printing, battery bins. We've had some reusable clothes drives and book swaps and things like that. So there are good things you can do on the floor, if you like, to sort of put the image of green HR out there. There will be longer term things, of course, that need to be done as well in terms of wider strategies and policy changes. HR should also engage with the workforce and unions and ensure key stakeholders are on board and are free to bring forward any ideas they may have in relation to climate change and green HR strategies. And for businesses which will diversify and change, HR experience in leading change. So there'll be certain businesses that will be slightly more resistant to this green HR movement, and so greater change in culture will be required within them. So HR will definitely have the work cut out in those types of scenarios. Just looking on there then, Rob, please. That's great, thank you. So what can HR specifically do? One thing that they can do is create sustainability objectives, and they can be both for the business itself in terms of targeted and initiatives they want to roll out, but it can also be for employees too. So you can have things such as having an objective in relation to sustainability being added into some of the employees' yearly objectives from a performance viewpoint. For example, get involved in one sustainability initiative per year, whether that be, get involved in a litter pick or something like that, or grow your own initiative. Policy and handbook reviews can also be undertaken. So HR may consider making changes to things such as their travel policies and encouraging the use of remote meetings. I mean, with COVID, I think we've all realized that remote meetings can be done and they can be as effective. I'm not saying that in every instance, but there can be an exceptions only basis to to travel and air freight and things like that. There could also be changes rolled out in relation to corporate gift policies. Reconsidered like things such as, do you really need those plastic branded pens or those plastic coffee cups, things like that. I actually had saw a LinkedIn article quite recently from an entity that they plant a tree every year for their employees' birthday, and I thought that was a really lovely initiative that the companies can get involved in. Other things that HR can do is to train on great initiatives, with employees and engage with them on cultural change. So do ask them for their view on it, what they'd expect to see, and any ideas that they have. HR can conduct sort of supplier review in respect of what great initiatives or ways of doing business their suppliers have, and they can refuse to do businesses with those that aren't engaged in green responsible business. If you're a business which is already looking at your supply chain, HR can get involved in the same way they would have when there was reviews being done for IR35 projects or in relation to modern slavery requirements. Home working can be facilitated, where business needs can still be met. Obviously, that's great because it cuts down travel for employees into work and therefore on emissions from car exhaust and things like that. But also from an employer viewpoint, it can be good because they can move to a sort of more hybrid working model and cut down on commercial rents. HR could also be involved in the setting up of green teams within work to discuss ways of greener ways of working with their employees and arrange those green initiatives that I've already been talking about, the litter picks, the food bins, battery bins, clothes swaps and things like that. The election of climate change champions is also a good way to deal with that, as it has someone with that specific responsibility for green initiatives. One thing I also just wanted to touch on finally is in relation to clashes of conscience. In other words, what happens when there are clashes of conscience and clashes in values in the workplace? This is something that crops up from time to time and is probably more likely to crop up as the Green Revolution progresses. HR may be able to take on the development of a strategy for dealing with employees who want to take part in climate strikes. Where there's a threat of climate strikes by business workforces, our advice to clients is always to engage with the employees, either directly or via representative bodies or trade union representatives as soon as possible to understand their intentions and their view on matters. Some organisations and some clients we've seen are actively encouraging their staff to participate in these sort of discussions just to promote their overall commitment to sustainability. As a business, it is worth assessing the likelihood of and suppose having a contingency plan in place for any large scale disruption to your organisation brought about by any sort of climate strikes. As a sort of legal side note, employees who refuse to work without employer consent will be acting in breach of their contract, and there are legal remedies in place that can sort of, employers can use to prevent those sort of wildcat strikes. But that said, we would always advise that early intervention and dialogue is much more effective than pure legal routes, which as you appreciate in themselves can attract unwelcome publicity as well as being quite costly. And perhaps a middle way to organise a series would be to organise a series of events to engage with your staff on the organisation's approach to sustainability, and offer staff an option to engage with walkouts on a limited and a pre-agreed basis. And when sort of dealing with employees on that basis and entertaining those dialogues, we would sort of suggest that the extent there is PR advice available, that you utilize that just to make sure the messaging is put out in the right way. Thanks very much. And then just moving on, Rob, thank you. Okay, so the next topic I'm just going to present upon today is in relation to menopause, or the M word, the change of life, the great divide, whatever you want to call it. It's something everyone will go through in life, but yet very few have been willing in the past have been willing to talk about until now. It's something, you know, it can cause a lot of disruption and issues for employers across the globe, and it's become very apparent that change needs to occur in this space for the benefit of both businesses and the employees as well. Just flicking on there, Rob, thank you. So as I say, most women will experience menopause at some stage during their life. The menopause can also impact trans and non-binary people who may not identify as female. So just to bear that in mind from a D&I viewpoint. Most of those who experience the menopause will do so between the ages of 45 and 50. However, there are instances where people will start to experience it a little bit earlier. Often the symptoms can last between 4 to 8 years, but they can continue on for longer. You know, nowadays there's increased rates of employment among women aged 50 and above, and that sort of means that more women will experience the menopause transition during their working lives. And to that end, employers should be aware of the potential for discrimination claims that may arise due to the treatment of women experiencing symptoms associated with the menopause. Some of the symptoms then that an employee with menopause may experience include sleeplessness, hot flushes, memory loss or poor concentration, headaches, muscle and joint pains, depression, anxiety. And there can also be some associated conditions that sit alongside menopause, things such as cardiovascular disease, osteoporosis, skin and hair changes, Alzheimer's, and things like that. The LRI does provide some useful guidance in relation to the legal position. They also have a helpful checklist for HR advisors or employers to consider when dealing with menopause in the workplace. They provide some best practice examples as well as a summary of some useful tribunal decisions. There's equivalent ACAS guidance as well, which has been developed for England and Wales. There's various reasons why employers and therefore HR need to take menopause into account. Firstly, from a litigation viewpoint, it avoids the risk of any claims which are costly and can of course attract negative PR. Not to mention, again, it's the right thing to do from a pastoral and employee wellbeing viewpoint. Secondly, to avoid losing valuable employee talent at a crucial point in their career. If you think about the age, seniority, and experience of women who are typically experiencing menopausal symptoms in the workplace, you know, it is worthwhile investing the time and resources in assisting staff through this inevitable change, just to avoid the leakage of great talent at that stage in their careers. Just next slide there, please. So I'll run through a few short case summaries that have come up just within the menopause sphere. Firstly, though, in terms of the legal position, statutory equality law does not expressly provide protection for menopause or perimenopause as such. However, women who suffer discrimination in employment that's related directly or indirectly to them having menopausal symptoms may, depending on the specific facts of their case, be able to seek legal remedies if alleging that they've suffered unlawful discrimination on grounds of sex, disability, or age. So in the Best and Embark on Raw Limited, an employer, in this case, an employer tactlessly asked an employee if she was menopausal after she made it clear that she did not want to discuss the topic. She was accused of being paranoid, petty, and obsessed when she complained about the menopause comments. This ultimately led to a verbal warning being given to her and her subsequent dismissal. The tribunal held that the employer had violated her dignity and created a humiliating environment for her at work. It also found that the claimant had been treated less favorably due to her complaints about the menopause comments made by her employer. Just next slide there, please. The Donaghy versus Talent Technology Services Limited then claim. The claimant in this one experienced hot flushes 7 or 8 times a day, alongside palpitations and feelings of anxiety, which would increase in frequency when she was under stress. She suffered from night sweats and sleepless nights, resulting in fatigue, anxiety, and memory concentration difficulties. These symptoms impacted her day-to-day activities. Her employer argued that this was typical of menopause, and so the impact was not substantial. The ET found that the impact of her symptoms on her day-to-day activities was more than minor or trivial, and therefore concluded that it amounted to a disability. It's quite an interesting one. Just clicking on there then, please. And then the Rooney and Leicester City Council one. the claimant relied upon the physical, mental, and psychological effects of menopause, which she'd experienced for a period of 2 years. This included severe perimenopausal symptoms such as insomnia, which there, as a negative multiplier effect, cause fatigue and tiredness, lightheadedness, confusion, stress, depression, anxiety, palpitations, memory loss, migraines, and hot flushes. She argued that her employer had failed to support her, which resulted in her eventually having to leave her employment as a social worker. She also argued that other work-related stress amounted to disability. Initially, the disability discrimination claim was dismissed by the tribunal. The judge decided that her symptoms and conditions did not amount to a disability. Upon appeal, the Employment Appeal Tribunal upheld the appeal against the decision that menopausal symptoms were not a disability. In this instance, however, the EAT did not actually have to assess whether menopause symptoms amounted to a disability under the Equality Act, i.e. whether they met the definition of amounting to a physical or mental impairment, which had a substantial long-term adverse effect on the employee's ability to carry out normal day-to-day activities. It only had to decide whether the ET had properly made that assessment based on her circumstances, and in that instance, it concluded that it had not. Next slide, please, Rob. Thank you. Yes, so just a little bit around the parliamentary menopause and work report that was carried out. It was a special report commissioned by Parliament, specifically the Women and Equalities Committee in the House of Commons, and it entailed them carrying out a survey and a number of respondents. The report offers insights into how menopause symptoms may impact work performance. Some of the key takeaways from it then, just to highlight, were that the respondents reported a loss of ability to concentrate, increased stress, and loss of confidence during menopause. 31% of respondents had to take time off work due to symptoms they experienced, so it's clearly not good from a staff attendance or productivity viewpoint. Less than a third of the respondents told anyone at work about their symptoms, mainly because of concerns around privacy, people's reactions, or because they simply did not know who the appropriate person was to tell. So again, the taboo around it can be something that's difficult for employees to deal with. Through the survey responses, Parliament collated a number of sort of practical steps employers could take to support their employees, such as fans and ventilation, but also more strategic initiatives, including policies and cultural reviews and changes. Other HR considerations then to be borne in mind from a practical viewpoint in terms of supporting colleagues experiencing menopausal symptoms in the workplace would be having a commitment statement for supporting women affected by menopause set out in all the relevant policies. So the types of policies you'll think about including such statements then would be any equality policy, harassment policy, or regional adjustment policy. Consideration of the impact of menopause when implementing relevant policies and procedures, for example, absence or performance and capability management, discipline and grievance, work and time arrangements, for instance, facilitating altered hours due to fatigue, or considering permitting home working. Environmental adjustments may also be something that you consider in terms of having fans available for individuals having a slightly cooler temperature, or rooms that can be altered to a cooler temperature, and access to cold water. Providing training to relevant staff, trade union representatives and managers, as well as raising awareness of menopause and relevant policies is something that should be put in place. And again, that goes to the, removing the stigma and the taboo that comes with menopause. Making managers and supervisors aware of their specific responsibilities to support women affected by menopausal symptoms is another key thing to consider. Conducting regular risk assessments in the workplace to minimise or where possible eradicate or remove workplace risks for women experiencing menopausal symptoms. Working with managers and supervisors in conjunction with relevant trade unions to promote a working environment that encourages women affected by menopausal symptoms which impact on their work, to discuss those matters with appropriate personnel, whether that be a line manager, human resources, or a wellbeing champion. Really just, sort of signposting them to anyone that is willing and able to deal with any concerns they have, and someone who they feel comfortable going to with any issues, because obviously it can be quite sensitive. Robustly challenging any negative attitudes related to menopause, and that really just comes with having an increased dialogue with it as well. Where relevant, referring staff to obtain appropriate medical support and advice, which may include accessing an occupational health provider. Conducting regular staff surveys, which include questions about health and well-being to include menopause. Monitoring the effectiveness of strategies and interventions to assist those staff members who are affected by menopause. And as I mentioned before, encouraging open conversation, increasing awareness and the significant impact of menopause, whilst obviously trying to normalise the conversation, always being cognizant of the fact that not all women will be willing, or feel comfortable speaking about the issue. So it's being supportive in the right way, and opening up those conversations, and I guess the ability to bring things up if they want to, and having people signposted, but equally not pressurizing anyone into speaking about something that they don't actually want to speak about. So the above are all just some practical steps HR can consider when dealing with menopause in the workplace. It's clear that's an area of shift in focus, and the tribunals will be expecting employers to take proactive steps to support staff members on the issue, not to mention obviously the business interests and benefits that come alongside supporting colleagues, particularly from an absence management, a productivity and a retention of staff viewpoint. So I'm going to hand over you now to Craig. Craig, you're going to continue on with the tomorrow's World of Work. I think you're going to talk about mental health.
I am, yep. So I want to cover mental health, and then bring us into some horizon scanning. So as if you didn't have enough on your plate, I'll flag some more stuff that you need to be thinking about in the next 12 months or so. So looking at mental health, then I suppose starting from a starting position of, well, is there actually an issue in the workplace with mental health? Hopefully most of us accept there is a need to consider mental health in the workplace now, but it's worth reminding ourselves of some of the statistics. So the Deloitte one gave me a fair amount of surprise. Not least because I'm still considered younger staff by their measure, being under 38. But more importantly, and more concerning than that, is the fact that survey found that nearly half of younger staff admit feeling anxious or stressed all or most of the time. It's quite staggering, and even more so when you consider that survey was just before we hit the real pandemic. So that was just at the end of 2019, just the beginning of 2020, that survey was carried out. So if you think that was the position then, and the well-documented impact that the pandemic has had on everyone, whether in the workplace or not, it wouldn't surprise me if that statistic was much higher now. Coupled with that, then the Business and the Community Survey, which found that 30% of the workforce will be formally diagnosed with a mental health condition in their lifetime. So it will touch all of the workplaces, but then it's how do we deal with mental health in the workplace? And some of the concerning statistics that came out of the Mercer report there, which said that managers who were surveyed stated that they had to at one point put the interests of their organization above staff well-being. A more recent survey from the Mental Health Foundation, released at the end of 2021, there found that managers who were asked, 65% of managers asked, felt that taking time off due to physical injury or illness is treated more seriously than taking time off to improve mental health. So I think those figures show that there's absolutely an issue in the workplace, but have we actually caught up in terms of organizations' view of mental health and the supports and education that is in the workplaces at the minute? And it seems that we're still lagging behind there. Rob, if we go on to the next slide. And one of the challenges that employers often face, and we get this from clients who've received a disability discrimination claim based on mental health, is they say, well, they never told us, we didn't know, so we couldn't actually put in the support that they needed. And absolutely, disclosure of medical conditions generally, but in particular mental health, is challenging. There's generally no obligation on an employee to disclose medical conditions full stop, and to include mental health conditions. And if an employee doesn't disclose, and we aren't able to ascertain through signs that there is something going on there, it absolutely can make it more difficult or sometimes impossible to support that employee with the challenges that they face. So we need to, as an organization, look at, well, why aren't employees disclosing? Why don't they feel comfortable to disclose, or just don't want to disclose? Is there anything that we can do with that? Touching on Ruby's point, there may be some people that simply don't want to disclose, and we should never force people to. But for those who don't feel able to, why aren't they feeling able to? And then how can we move to a situation where those who feel comfortable, or create an environment where those individuals do feel more comfortable to disclose, so we can ultimately provide the support that they need? And what we're finding, and employees who are surveyed are saying, is there's a fear that, one, they'll be subject to discrimination, a fear that they'll be sidelined. So you can see there, the statistic from Mental Health Foundation, the same report at the end of 2021, 38% fear that revealing a mental health problem at work would jeopardize their career. That's significant and worrying, because we'd like to think that actually it wouldn't in most organizations, but it's the fact that that employees still feel that whatever culture change we're trying to bring in, it's not hitting employees, and it's not feeding through to them, and that fear still exists. So that's something that we need to look at the reasons why. But on the disclosure, one of the concerns from employees is, well, who will find out? Will it be the talk of the office that I've got this mental health condition? And it really is trying to be transparent and clear with employees what we will do with that information if they disclose. And quite often, our use of that information will be quite limited. So it may be simply to refer them to occupational health, to share that with their line managers so that appropriate steps can be put in place. And it's talking that through with the individual and giving them the comfort that the reason we're doing that isn't to tell the line manager so that will jeopardize their career and we can make sure they're put to the bottom of the pile for promotions. Absolutely the opposite. It's there to ensure that we can put the support in place that they need to help them develop their career and continue in the workplace. So it is making sure that managers and HR, when we're dealing with return to work or long-term absence, that we are ready to give that clarity and transparency as to what we do with that information where we are referring individuals to occupational health. What we then need to consider as well is there anything else in the environment which is stopping them speaking up and flagging concerns that they have about their mental health? So feeding back right through from what Paul said and through to Ruby as well, around if there are instances where individuals have raised concerns about feeling harassed or being discriminated, are our managers putting a stop to that as soon as possible and reinforcing the business's view that needless comments about someone's mental health or their illness or their time off is not appropriate, and that we're, as an organisation, showing that we're prepared to take the steps to knock that out. It's all about building that environment that individuals feel able to speak up. It is, however, important to remember that whilst individuals can let us know about their mental health conditions or the medical conditions, ultimately it doesn't matter if they don't in terms of our legal obligations, because the test isn't whether they've told us, it's whether we knew or whether we could reasonably be expected to know. And again, this is where some of the education piece comes down for managers as well. So the Equality Commission have given the example of an individual who continuously comes to meeting in tears and feels really down in themselves. It's reasonable, they consider it reasonable in those circumstances, to ask questions of the employee around whether there is anything that they can assist with, any medical condition that the business needs to be aware of. It's educating managers so that they're aware of some of the signs, not for the managers to diagnose in any shape or form. We don't want to ask them to do that. They're not well placed to do that. But it's picking up on the signs that actually, I need some help with this. This employee might need some help. We need to be able to signpost and make sure that we have the correct processes in place. Next slide then, Rob, on that. I think we've gone backwards. Skip it forward another couple. And one more then after that. Brilliant. So what we want to do is create that supportive environment so that individuals feel that they are able to talk openly about mental health. So going back to that statistics where I spoke about, 65% people of managers said that they felt that physical and mental health weren't treated equally. Well, there needs to be a culture shift in that. The other statistic that came from the Mental Health Foundation report was around 45% of employees said themselves that if they felt they needed time off for mental health reasons, they would make up another reason, a physical reason. I've got a sore head, or I'm feeling sick, because they wouldn't feel confident that that they would be given the same leeway or support as if they had a physical health condition. So we need to look, why is that still the case, and are any of the messages we send out treating those conditions differently? Particularly with the shift towards hybrid working, I know some businesses are still fairly remote, others are moving back towards the office, but regular one-to-ones are also important with managers. Again, making sure that our managers are aware of the types of issues they need to be picking up on, and making sure they realize it's not a counseling session, but even just checking in with employees that are working remotely in particular. Hybrid is great, great benefits for some employees. And it's not to say don't go hybrid or don't go remote, but it's realizing that, and I've seen it myself, that you can feel a disconnect from your team. You can end up feeling you're working somewhat in a silo. Issues that come through suddenly seem much bigger because you don't have that opportunity just to offload to someone sitting at the next desk. So it's thinking about, how do we ensure that we're still engaged and checking in on employees and creating an environment where that employee feels that their manager is open and willing to listen. It might not be that they've decided to offload everything, but at least they know there's a listening ear there. And it's encouraged the managers to feel confident in the sort of questions they can ask. So again, coming back to the education piece is really important. The other way we can demonstrate to our employees our views on the quality of mental and physical health in the workplace is celebrating things like World Mental Health Day, arranging mental health awareness training. In Pensance, we have mental health champions. So those are people who are across different offices and are highlighted as being people who can, again, not counsel, not be there to be the given all the support, but people who we can go to as a staff and say, look, I'm struggling, who can I go to support, or just be a listening ear, and do that signposting if needed. So it's all about that, creating a supportive environment. Ultimately, like a lot of these things, where this needs to come from is from the top. You need that management buy-in. So again, because it's the senior individuals, the board, the senior directors, they set a lot of the tone and culture about a workplace. And those individuals, particularly in senior management, who are willing to be the champion for the organization, or even those who have had their own mental health conditions, or still do, and are willing to talk about that, they are an invaluable resource. We've had a number of partners and senior members of the board speak about their mental health challenges, and it's really encouraging, and it again helps demonstrate an organization that is putting mental health at the forefront as well. So some thoughts there around mental health and the sort of things that we can do in terms of creating an environment. Rob, just on the next slide, and I won't go into detail on this, but it's ultimately a reminder. Of course, there's the legal part. If a mental health condition becomes a disability, then there is that duty to make reasonable adjustments. Of course, a mental health condition or mental health in general, we don't have to wait until it becomes a disability to offer those supports. But just a reminder that if it does hit that definition of being a disability, that we need to be considering what reasonable adjustments can be made. There is an interesting discussion going on at the minute around whether COVID has shifted the bar that bit higher in terms of what might be considered reasonable. So certain organizations that before may have said, actually, working from home 3 days a week just isn't possible. We've seen that shift can happen. So it'll be interesting to see whether that bar has been set higher in terms of the flexibility that employers can actually offer if pushed. The only other thing I'd say on adjustments, what we often see from clients is saying, well, we've done this, we've done that, we've put this support in, that support in. When we think about our duty to make reasonable adjustments, what we need to be thinking is, well, what is the thing that's putting this individual at a substantial disadvantage? So what is the practice criteria or provision that's actually putting that individual at a substantial disadvantage? Because that's the thing that we need to adjust. So it's not enough just to say, well, we've given them time off, we've allowed them to come in a bit later. If that doesn't actually address the substantial disadvantage, you haven't met your duty to make reasonable adjustments. So just that to bear in mind. Okay, turning then briefly to horizon scanning. because we want to leave a bit of time for Q&A if there's any questions. Few things just to flag to you in that flurry before the election. We've seen a few things prop up. Well, there's the annual uplift in limits for the employment tribunals. As always, lovely round numbers to make it nice and easy to remember. So it's the maximum weekly pay from the 6th of April is going to be 594. Maximum compensatory award in the tribunal for an unfair dismissal claims gone up to 94,000. So it's just worth bearing in mind if you are thinking there's going to be a project, potentially redundancies, to factor that increased cost. So any dismissals after the 6th of April will be on those rates. Positive news coming through the parental bereavement leave. So there's going to be an entitlement to, again, from 6th of April, 2 weeks bereavement leave. And 2 weeks statutory parental bereavement leave pay. So it's the £156.66 per week. If you have 26 weeks continuous service on the pay, the leave is day one, right? They are looking to remove that requirement for the 26 weeks for the statutory bereavement leave pay. Along with that, you've got the same protections from dismissal and detriment as you would from other family leave. The bit that sets us apart, and it's always nice to blow our own trumpet in Northern Ireland because quite often we feel we lag behind. There is provision that that bereavement leave will be extended to those who lose a child through miscarriage. That is subject to further public consultation, but it will be coming in before April 2026. So a bit of time to wait. But that will set Northern Ireland ahead of any other European country in making that provision and recognising the impact that miscarriage can have on families as well. So good news in that. The next one then, we've seen the Fair Employment School Teachers Bill. That's just waiting royal assent. So that was cross-party support on this, removes Article 71 of veto. So important to bear in mind if you employ teachers. Will now have to monitor the community composition of those applying for jobs, those appointed and those promoted. So effectively put teachers in the same place as any other employee would be in terms of being able to bring a complaint of religious discrimination relating to the recruitment as well. So that snuck through. Rob, next slide then. Couple of bits that didn't get there or are still waiting on. Gender pay gap. Still no sign. So of course we've had the Enabling Act since 2016. We've seen the Republic of Ireland are going to start theirs this year in 2022. GB have decided not to go with the mandatory ethnicity reporting. So instead they're encouraging voluntary reporting, and there will be BIS guidance released in summer 2022 to enable employers who do want to voluntarily report on ethnicity. It will give some guidance as to how that might what that might look like. Some organisations, so I know here at Pynsent's we already report on gender, LGB, race, ethnicity and disability. And of course, when our gender pay gap regulations eventually come in Northern Ireland, there will be that requirement to report on ethnicity and disability. So it really is worth looking out for that BIS guidance this summer to get an idea as to where they think the challenges will be and what that ethnicity reporting might look like then in NI when it eventually comes through. I'm anticipating I very much hope it'll be in the next mandate, but fairly in the next sort of 6 to 12 months after the election, assuming we have an executive. So there is a lot more push now for Northern Ireland. We are the outlier here. We need to get back up to speed on that. 0 hours, again, that was provided for in the Employment Act 2016. The removal of the exclusivity clause in 0 hours contract, so fall in line with GB. There was a non-executive members bill that was put forward that went further and suggested that there should be bandit weekly working hours. So for example, if you continuously worked for 16 hours per week, eventually you would have the right to be banded within that, regardless of your contract, and it would be amended to then state that your minimum was 16 hours per week. That didn't get through in this mandate. I don't know whether that bill itself will get through in its current form, but certainly we'll see some more around 0 hours once the election's back over and done with. On the next couple of slides, as we will send these through, I'm not going to go through these now. These are some of the other things that we see are going to be on your agenda for 2022. The only one I'll mention there, restrictive covenants there is that expecting that consultation, the government's response to the consultation to come out. Again, that's a GB consultation, but it will probably feed through into how NI will move towards restrictive covenants as well. But the last couple of slides, as I say, show what should be on your agenda. I think we'll leave it there. If there are any questions, I think we're happy to take those now. If there's any on the chat, or else anyone wants to raise their hand and raise them, more than happy to take questions on any of what we've discussed, or anything else, as long as it's not too hard.
Thank you very much, Craig. There's a couple of questions that have come in. The first one is in a question for Paul, which was, I assume, around the Uber case. The ability to provide the service provision personally, has that changed the definition of what it means to be a worker?
No, that's still what's coming out from the cases, but also what's in the legislation. So someone to be a LIMB worker, either under the Employment Rights Act or the Employment Rights Northern Ireland Order. So someone who does provide the services personally will still fall under worker. So the Uber case didn't actually change that. It was more in relation to when the contract started. So when do they start to provide the services personally?
Great, thank you very much. The second question is just a bit more broad, I suppose, is around top tips for managing and supporting mental health in SMEs where they haven't necessarily got the infrastructure around them that makes these things slightly easier. What are the top tips that you've got for people who are maybe in a standalone role?
Yeah. There's a number of resources out there that are really helpful. I've mentioned a few times the Mental Health Foundation have a checklist for employers that's really useful to work through to see how are there areas that, even as an SME, that you can be actively addressing. I think engage with your peers as well. So the CIPD is great for that, and saying what knowledge and advice is out there for what others are doing in your sector and organisations. Mental health charities as well, the likes of Aware, again offer a lot of support. So the information and even training is out there, and certainly for any SMEs that are want to have a chat as to what we've done in Pinson's around mental health champions, etc. That isn't a big investment in terms of money. It's something that organisations can do. I'm more than happy to have a chat with those guys as to the sort of things that we've been doing here, which again, I say that they're not thankfully not resource heavy as such.
Great, thank you very much, Craig. There's another question that's just come in around the question reads, the new domestic safe passage legislation for employees to flee. Is there any update on this, and if this applies from the 6th of April?
I'm not aware that there is any update on. I haven't seen any update on it as yet. Paul, I don't know whether you have.
No, there's not. No.
Yeah, which is unfortunate.
Final question.
I maybe just pick that up because it was me that put it in. It's Karen Gilmore here from Clanwell Housing. That was one of the other pieces of legislation that went through at the end of right at the end of last week, at the end of this mandate. And there was a provision for paid leave for employers to have paid leave for anyone in a domestic abuse situation to flee, really. And I just was wondering, was that in the same timeline as the other ones that you've referenced today?
Yeah, I'm not sure. I wasn't sure whether it received royal assent, which the other one is the fair employment one's waiting for as well. If it does, it will then have the commencement order that follows thereafter to confirm. But yeah, we can certainly keep an eye on that one.
Great, thank you, Karen. The final question is just around the gender pay gap that you referenced there at the end, is around what's the best course of action, I suppose, is the question around if you employ people in England and in Northern Ireland?
Yeah, organisations have taken different approaches to this. So strictly speaking, if you have employees in Northern Ireland, you don't have to include those in your gender pay gap at the minute because they are employed in Northern Ireland. Some organisations, I know Pinsent's here, have included NI employees. What you need to bear in mind if you do that is that ultimately there are going to be changes and differences in the NI regulations as against GB. So it's, for example, there isn't clear clarity as to whether we'll do the same median and mean calculations, whether they'll be the same quartiles that we split it down into. And in addition, then, of course, in NI, we are going to have the requirement to have action plans. So if there is a pay gap in our organisation, we need to produce an action plan as to how we do it. So absolutely, there's lots of learnings in terms of if you've got a GB organisation, you're already ahead of the curve in terms of how we collect some of that data. But we need to be looking to see, well, what will that ethnicity and disability data look like? That's why I mentioned keep an eye out for the BIS guidance on that, so you're up to speed. But also then consider what are we doing to address that gender pay gap that we have in GB, if we do have one, because that's what some organisations voluntarily report. There is no obligation in GB to actively have an action plan. So it is trying to get ahead of the curve. If we do think we have a gap there, what are we going to do? How are we going to present this to our employees? That's going to be the key bit.
Brilliant. Thank you very much, Craig. Hand back over to Beth.
Yes, thank you. Look, just to close off, I'm conscious of time and I know a few people have already dropped off. So a massive thank you to Paul, to Ruby and to Craig, all from Pinsent Masons. Really, really informative session. Very helpful information in there. So I'm sure everyone will be looking forward to not only the recording but the slides that come with it. So thanks to all three of you for putting all of the time in to prepare for today, and obviously to deliver the session. We really do appreciate it, as always. And yes, there's lots of useful resources out there on all of the issues discussed, and CIPD has lots of resources on offer as well. So look, it leaves for me to say thanks to all of you for joining today, and we do hope that you found it very useful.